Hi, nice to meet everyone. My name is Fatima Khan. I'm a advisor for the Rise of Privacy Tech, and I work on privacy at Okta. And this panel today is about why startups need to prioritize privacy before IPO. And we have like a great panel lined up for you that have experience both with emerging companies and with public companies, advising them through their journeys on privacy from start to finish. So first, let me kick off and have Shannon Yaworsky introduce herself.
Great. Thanks so much, Fatima. I'm Shannon Yaworsky. I'm a partner in the cyber privacy and data innovation practice at Oric, based in San Francisco. I'm an English and Irish solicitor, so I actually went to law school in London and practiced European data protection law and technology transactions in Europe for 12 years before moving to the US about 7 years ago. So I cover a whole range of US privacy and European privacy. And I also spend a lot of my time in corporate deals and with startups and growth companies. And I'm thrilled to be here to talk through these issues on this panel with Fatima and Adam.
And then hopefully Adam just joined, and I'll give him a second to introduce himself. Adam, can you hear me?
Yes, I can. Can you hear me is the big question.
Yes, great.
Okay.
Right in time.
Great.
Yeah, thanks for bearing with me. I'm Adam Connolly. I'm a partner in the cyber data privacy practice at Cooley, based in San Francisco. Nice to be with you all.
Well, thanks, Adam and Shannon. So I'm actually going to kick off our panel, and I'm going to pose a question to the two of you, and maybe to do some chiming in myself. First, I'd like to really understand from you two, from a privacy and security perspective, what should startups really focus on early on? And then can you talk to the earlier stages, so maybe the seed, A and B times?
Sure, I'll let Adam kick off.
Sure. So I think most often when we hear from seed companies or early stage companies, the first thing we hear about is a privacy policy. We're about to a larger closed beta, or we're going to do a launch, and we need a privacy policy, and that's important. That's one thing to consider. So I'll just talk about. It's not the only thing to consider, but let's talk about just the privacy policy for a second. It's not all companies that call a law firm to ask about that. Lots of times companies will, frankly, just try to cut and paste a privacy policy that they've seen somewhere, or from a company they think is maybe similar, and don't do that. The truth is that maybe 5 years ago, the risk of doing that would not have been as great, but we're in a different world now where there are real incentives not to do that. So what should you do, right? So obviously you should hire Shannon or another lawyer or someone else. But if you're just not going to do that, it would be better to find a good template with guidance that can actually walk you through the considerations on what to do and what not to do when something might or might not be relevant. And there are various vendors that offer those, and some law firms that can give you kind of a low cost template. So that would be a much better starting point. And then just a few kind of rules of thumb on that. Don't make a lot of promises that you're never going to do something, or you always do this or that. Those can backfire down the road, and it may turn out when you thought that it was true that you were never going to sell data. You never know if a California ballot measure will redefine what it means to sell data and put you in a little bit of a bind. So it's best to just describe how you collect, use, and share data in a straightforward way, but don't make a lot of emphatic statements about privacy assurances that everybody can bank on. And also just be mindful that each version of your privacy policy will matter. We're going to talk later about due diligence and venture financings and other transactions. But one of the things that Shannon and I will look at is not just what your current privacy policy says, but what your prior version said. So you just be mindful of that. You don't want a total piece of junk at the outset, because just because you update it doesn't mean that it won't be relevant in assessment of privacy risk. And then also just don't assume that stuff that you see in a privacy policy applies, right? So there's lots of talk about CCPA and GDPR, but those don't apply to everyone, especially at the early stage. In fact, it's the very early stage for US companies, it's most of the time in my experience, they don't apply. So don't assume that you need to give all of those disclosures. There are good resources out there that can walk you through when those laws become relevant for you. I've got a couple of flow charts up on the web that I can point you to if you want to reach out. But don't think that just because some company that you're looking up to has said something that you need to. So that's privacy policies. But Shannon, why don't I stop talking and let you hit some of the other stuff?
That's great guidance, Adam. I think that's right to focus on the privacy policy. And one of the things I'm fond of saying is the privacy policy should, you need to say what you do and do what you say. That's the sort of rule to live by. And I like that Adam highlighted not to make any, absolute promises like we're never going to do this or we're always going to do this. Like don't over promise. I think another thing I think of as being two other things I think of as being really important in the early stage. One is considering or having a good understanding of the regimes that apply to you. So like Adam was saying, does the GDPR apply? Does the CCPA apply? Figure out what framework you're working within and make sure that you're aware of the big restraints that you might have. For example, if there's children's data at issue, you need to think about COPPA issues very early on. That's not something that you can sort of delay. The other thing I like to tell people to think about at a really early stage is privacy governance. So it may be that, at the outset, you're not going to have a chief privacy officer, or you're not going to have someone whose only job is to think about privacy and data security. But make sure that there is one person within the organization that's on their list of responsibilities to be primarily responsible for those things. So I think in highlighting really core things, like Adam said, privacy policy, what are the laws? Like, what is the world that you're living in? The rails around what you're doing with data, and make sure that there's someone charged with being responsible for privacy and security.
So super great point, Shannon. And then one thing I just want to stress is, since this is specifically an audience of privacy tech founders and privacy experts here, as well as VCs, like nobody wants to invest in a company that is, for example, getting in large amounts of data from their customers or consumers, and then they have a breach, right? So even though a lot of these privacy laws don't apply to you, you still must be mindful about it to some extent, because if you're selling off of privacy and this is your differentiator, and then you're breached or it's discovered that you're operating in God mode, there goes like your revenue, and there goes any potential rounds that you're going to raise on later. So, you don't have to be perfect, but definitely be mindful about what you do and take a risk-based approach. But then moving on to the next step, let's talk about due diligence. And when you're raising around, getting into CD or later stages in your startup, like what have you seen has been essential for passing diligence, especially when you are in this position of dealing with large amounts of customer or consumer data? Like, what do VCs expect to see so that they do make a choice to invest in you rather than not?
Well, finally, you touched on an important point, right? The easiest way to raise concern when you're raising money is to have had some security incident. So kind of going back to the prior topic, right? The privacy policy is important, but data security is important as well. In the very early stage, you're not going to have the resource to have a chief information security officer or a dedicated InfoSec function. But just as Shannon was saying with privacy, that it's important to make it someone's job. Same thing with security. So in practice, oftentimes it's whoever's running engineering, the head of technology is sort of looking out for that, and the team is hopefully engaging in good security hygiene as they build up the product. But I think it's important to do more than that and actually make it someone's job to take a step back and think about, all right, are we actually taking some steps to consider what the risks, the security risks to the product and the business are, and are we doing some things to mitigate that, right? And it can be pretty basic. So lots of companies are building their products and services on AWS or other cloud environments. And AWS has great guidance and tools on how to use those resources securely, how to implement encryption and manage encryption keys and so forth. So making sure that you are following that guidance. And also just looking at some of the industry guidance, right? There's the OWASP top 10 security vulnerabilities that folks should be looking at. FTC, the Federal Trade Commission, has a good basic reference called Start with Security. That's basically a checklist of the types of things to be thinking about. And the value of doing that is that not only are you reducing your security risk, but those are the things that Shannon and I will ask about in due diligence to see if you've been doing those. And so to get back to your question in terms of what are the issues that come up in due diligence when you're raising a round, it's definitely security. So what have you done, right? And again, investors are realistic in terms of what to expect from a very early stage company that doesn't have a ton of resources to build out a security function. But we do want to see that you've taken some steps to have reasonable security measures based on your place on the maturity curve, right? And so what does that look like? It's the stuff I was just describing. If you go to that Start with Security reference, you'll get the sort of checklist. But one easy thing to do to project maturity is to have a written policy, right? If you have even if it's simple, it doesn't have to be highly elaborate, but if there's nothing by way of sort of security policy documentation, no internal procedures, no references, no sort of incident response plan, then what that says to investors doing diligence is that there's not much there in the way of security maturity, and that would be something flagged in a diligence report. And then the other thing to be aware of is that many venture financings are based on the form documents used by the National Venture Capital Association. You can go to their website and you can download these form documents. So there's the ones to look at. There's a stock purchase agreement, which is often the sort of core, the foundational agreement for the raise. There's also an investor rights agreement. Those both have in the stock purchase agreement has certain representations and warranties that the company raising money is going to be expected to make as it relates to privacy and security. And then the investor rights agreement has certain covenants, obligations that the company is going to have to take on moving forward. So it's a good idea to look at those to see what representations are you going to be expected to make when you raise your round. And Shannon, I don't know if you maybe want to talk in more detail about the types of things that are addressed in those provisions.
Yeah, that's a really great point to look at those documents. I think another related point is if you can get your hands on to be aware of some of the questions that you might be asked in the context of diligence and be prepared for those questions because project maturity. So like Adam was saying, similar to having a privacy policy that is accurate, that doesn't unnecessarily speak to CCPA or GDPR, is also going to project maturity and being able to your privacy startup being able to talk the talk, like being aware of the lingo. So I think looking at this questionnaire and being aware of the questions that you might be, your story prepared about what you've done with respect is going to put you in a really good position. And I think to Adam's point, looking at the documents that you're going to sign about have in place a privacy notice, whether you have with all applicable laws in relation to privacy and data security, that you're able to represent that there have been no data security breaches. Those things are all going to go putting you in a really good position when you're raising a round.
I'm going to talk to that actually something else that has an indirect effect on this, and we're going to touch upon the customer expectation piece a little bit later, but I think a lot of it and what you need to have in place really comes down to what your more sophisticated customers will expect. So as you grow as a startup and get those more sophisticated customers to bring that revenue in, they're going to expect to see more sophisticated privacy practices and privacy marketing, as well as functionality on their end from you. So if they don't see that, you're not going to get the revenue in, you're not going to get those names in that you need to be able to raise your next round. So I think while you may not directly always have key privacy questions as part of that fundraising questionnaire, it's going to come through indirectly, especially if you're a privacy tech startup. And then just to maybe add to this, do either of you two have any like good war stories from any clients that you worked with in the past where they failed on privacy, right? And then you saw some type of actual impact, whether it's at the IPO stage or if it's let's say they didn't go to IPO and they were going to have M&A and that fell apart. Like, can you give me an example of what that looked like? Of course, on an anonymous basis.
Yeah, sure. There's so yeah, it can take lots of different flavors, right? So I'd say sort of at the low end of the spectrum in terms of a consequence of a kind of a compliance gap or an issue in diligence. Let's say if it's a venture financing and you're raising money, it might just be as simple as one of your directors who just invested in you has some concern, right? And I've seen this a number of times recently with respect to GDPR. So back in 2018 when GDPR was brand new, even 2019, there was a little more tolerance for GDPR compliance gaps. The law was new. Everyone was still figuring it out. Everyone was in process of figuring out what controls to put into place. And I definitely saw more understanding of them and more tolerance. As GDPR enforcement has ramped up, and it's ramping up in a big way, that the level of concern has also increased. And so, what you might see at a minimum is a board member saying, I have some concerns. The company this is a strategic thing, and they've done nothing on this. So I'm going to use my, tell me what I should do in my capacity as a director to kind of lean on the company to get its act together, right? So it could be just as simple as that. You've got a board member who's focused on this thing and is going to be following up with you. If it's a more serious issue, right, and it depends on the risk, right? So if you're a company that's handling more sensitive data or higher volumes of data, and there are compliance gaps, then there will be greater concern. And so it could be a covenant in your financing documents to close a compliance gap within the next 6 months, within the next year, and before the next raise. And I've had quite a few clients kind of call me saying, hey, I forgot that I had this covenant in my Series A, and can you help me get into compliance with GDPR next week? And the answer is no, because it takes more time than that. So yeah, you don't really want to be going into the next round, in violation of a covenant of your current financing documents. In an M&A context, where especially if it's private M&A, where you've got a company that is buying another company is going to own the company and all of its risk, you've got a higher level of scrutiny. And there is actually quite common that if there is an actual liability or potential liability, like right now I'm in the middle of an M&A deal where there was a pretty pretty significant data breach, not the worst, but enough to attract a class action claim and an FTC inquiry. And so, there's going to be not only an obligation of the company to indemnify the buyer against the liability arising from that, but a certain amount of the proceeds of the sale are going to be set aside for a couple of years. So it's there in case the buyer needs to call on that indemnity. So you're going to have the proceeds of your sale being held back to try to in the event that the buyer needs to call. And then I can't say that I've done one personally, but there are reported stories of some deals where there's been a price haircut because it's usually a data breach is so massive and going to be such a significant liability that indemnity is not enough, and it fundamentally changes the value of the company.
I think that's right, Adam. That I've seen come up increasingly is GDPR. And I think that's because everybody knows that there's so much risk associated with doing it incorrectly. And the regulators are active. And, you know, it's a privacy law that's on the Wall Street Journal. The fines are so significant. And there was, I think that there was a question what enforcement would look like, clear that the regulators are not having any issues sort of, you know, exercising their powers. We've seen a lot of, you know, we've seen the blockbuster fines that have been issued just in the last 6 months. So there's laser focus on GDPR issues applies to what you're doing. I would, to pick up on Adam's point of the covenant, I've seen this a few times that there was a covenant previous round and they just haven't fixed it. And I see that too, like, oh, well, it's you. Can you fix this in the next like 5 days? And the answer is no, I can't. I'm sorry. There are limits to my that. Recently there was a deal where this company had recorded a ton of calls, and they were like, we have all this great data. We recorded all these calls, but they didn't do it state wiretap laws, and the result was there was, you know, risk associated with that bucket of data, and as a result, we asked them to delete it all, right? So it could result in having to delete significant tranches of data did incorrectly. So that's something I think that's something to think about also. Another thing I've seen recently is, and this is in M&A, in a big M&A trend, where they hadn't, you know, cross-border data transfer right now is so fraught because of the Schrems decision guidance. There are lots of issues, and essentially not very many people are doing it. I don't know if anybody can say that their data transfers are perfect and they've conducted all of their transfer impact assessments, but it's nevertheless a risk that the buyer is taking on. Because, you know, as of the Schrems decision, as of July 16th, 2020, that was the law. And so anybody who's not doing it right is in violent time. So that's something that's come up just in the last 6 months. And it's tricky because from the sell side, they're like, well, nobody's doing it right exactly, and we're starting to do it. But the answer is that may all be true. However, there's a lot of risk, and we think that you should be responsible for that risk. And so there's a sort of risk exercise that goes on in figuring out what the level, if there's going to be a special indemnity or a special escrow, and I've seen, you know, several different conversations about that specific issue just in the last, and I'm sure it could be an issue going forward because it's not resolved as a matter of law. And there's just, you know, in privacy, there are a lot of gray areas. So I think that's something to focus on also.
Yeah, great point about taking a risk-based approach, especially in such an uncertain and developing environment, Shannon. On top of that, I would just add, just from public incidents around privacy inquiries by the FTC and just privacy class actions and other investigations, that has like a twofold impact. Oftentimes, one is reputational, right? So especially if you are selling to enterprise customers, it could be seen as a setback in their eyes if you are facing a privacy inquiry or a privacy class action for that product set. That's one big impact. The other is there's oftentimes like a fluctuation in the stock price, right? So your stock price might take a dip either for the short term or the long term, depending on what that privacy impact is. So, I mean, it's something to always be mindful of, to have enough in place to make sure you don't attract the regulators knocking at your door in the first place. So moving on then to customer expectations, I'd also like to learn from each of you, what do you recommend as a big focus? And then my ask is, maybe Adam and Shannon, can one of you each focus on B2B and then B2C? And I'll let you pick and choose which one you want.
Yeah, so I think well, I would suspect most of the audience is in a B2B capacity, and so it's also selling B2B services. Selling privacy tech raises a couple of interesting issues, right? But generally, any B2B company where there are data issues, right? So if you're a SaaS company and you want to sell your product, you need to get the customer to trust you with their data and to to get confident that you're going to not create problems for them under their own obligations with GDPR, CCP, or whatever else. Privacy is a key sales topic, right? It's you really need to have a sales engineer who is conversant in privacy, and often as a B2B company, even more important than the privacy policy is an FAQ or a marketing document that can get your customers comfortable that you know what you're talking about, that you've got a plan for addressing these issues, and that they can trust you, or you're not going to get any money in the door. And so that's really a key document when if you've got any B2B business, but that's more even more so when you're trying to sell privacy tech, right? Because you want to get them to trust not only that they can, you're going to handle the data responsibly, but that you got a product that is designed appropriately for whatever compliance problem it's trying to solve. So projecting that maturity and knowing how to talk the talk, obviously essential. But Shannon, I don't want to monopolize B2B because there's contracting and everything else. So would love to hear what your thoughts are as well.
Yeah, I think there's some similar in B2C. I the idea of having FAQs, and I really recommend that for companies, especially in the privacy space, because there's still a lot of mystery for people around how privacy works, and what you're doing, what technical features you're offering that is more protective of data, or how it's gonna help the company. So being able to really granularly speak to those things and having your salespeople that information is important. I would say also training those salespeople, like having a training session on, hey, look, guys, this is the privacy working within. This is what our product does. This is how the product helps solving. This is how it solves the problem, or how they're part of the legislation. I think is really important, is being able to show people what that value is, and having your sales sort of aligned around the story, around the privacy story, and you're selling. It's great.
Oh, sorry. I was just going to interject with an important point when you're developing the FAQ and your sales pitch and your materials, is to watch out for the over-promising on privacy compliance, right? And you see this sometimes. Our solution will deliver perfect compliance with GDPR. Well, who knows what compliance with GDPR is, right? And are you sure that you're delivering that? And so if you actually look at kind of the bigger SaaS companies out there, and you look at their materials on GDPR and security, it's worded very carefully. It's, we are prepared to help you comply with GDPR. We are GDPR ready. We've got the tools that you can use to help yourself comply with GDPR. So you don't want to make statements that can come back to haunt you if something goes south and your customer is accusing you of overpromising.
Yeah. I was just going to say, great points, both of you. And then, on the B2B enterprise side, privacy diligence and making sure that any liability attached to it is like top of mind, especially with Schrems 2 and the point Shannon was making earlier about transfers. So making sure that you have in place something to be able to sell to your customers on the enterprise side, especially if you're B2B, incredibly important. And then as you see from the B2C side, becoming even more and more important as soon as people saw WhatsApp change their policies to be able to share with core Facebook. There was that mass exodus of people using that Messenger app to go to Signal. So you want to make sure that any of the communications you have out there with regards to privacy and your practices are pretty clear. So just going onwards to the next question, and then touching upon what Adam said, you don't want to make a silver bullet promise out there to any of your customers or any of your users about privacy. So when you actually are selling privacy tech and using privacy or some regulation to sell off of? Like, have you seen any shift in expectations from a customer? Like, when do you think you should bring in somebody to help lead those conversations in your marketing there?
Shannon, you wanna take that one first?
Yeah, sorry, I froze for a second. It's a great question. I mean, from my perspective, bringing in an expert as soon as possible is great. Make sure that they are helping to build that's not realistic. So for very early stage start in conversations with your peer companies to get advice about what they've done in similar scenarios, I think would be helpful. But bringing in an expert as soon as, even if it's just for a certain period of time, to help you with the setup and really think through the core issues and help you develop a roadmap. Maybe you're not going to be fully compliant with GDPR in months. Have a roadmap in place and have.
Shannon?
Sorry, I think I'm back.
Okay, yeah, I think you're back. We had lost you.
We got
Okay.
to the road. We got the road.
The roadmap. I think the roadmap is critical. So you be fully compliant with everything from the very beginning. And I think people recognize that, and investors recognize that. I say in those early stage diligence reports, there's an immature privacy compliance posture. However, it's not inconsistent with similarly situated. So know that people recognize that. But if you are able to show them that you've thought about the future, you've thought about the milestones that you need to meet in order to be more compliant or fully compliant, that's going to go a long way. And so, earning the trust of the investor that you obligations are, and you're planning for them, even if you can't do everything right now.
Yeah, I think that's right. I mean, obviously in the early stage, you don't have the luxury of hiring a full-time in-house, privacy specialist necessarily. But if you do, just consult with an expert to make sure that you're aware of what the real issues are and that you're making some progress towards those. Then in diligence discussions, it just makes a world of difference when in the first conversation, the investors or Shannon or me are listening, and we hear that somebody at the company, they know what the issues are, they've taken at least some steps to address them, and they know where they're going. That just changes the whole tone of the process. You just immediately have a much higher confidence that this is a company that's oriented in the right place and knows what they're doing, and that can be that can be hugely valuable. So yeah, it's not that you need to spend the money on a full-time internal resource. Good luck if you wanted a chief privacy officer. Good luck hiring one. It's a really tough hire. But yeah, just giving that strategic outside advice, which doesn't necessarily have to cost a ton of money. You don't even have to use them to do all the work, but just to steer you in the right direction, so you know what story you should be telling other stakeholders.
Yeah, those are wonderful points, you two. And then as somebody that buys privacy tech and really a customer of B2B solutions, oftentimes, like when I see somebody making such a broad claim about privacy that's inaccurate, or presenting the way that privacy laws actually are in a way that's factually incorrect, they lose credibility with me, right? And if you're a privacy startup, you're not in the business of losing credibility with your buyers right off the bat. That's something, you want to totally avoid doing. So it's really important to get the right people on your team early on and to give you that advice that you need to position yourself correctly in the market. And then I know we're running up on time, so I just wanted to finish up with one last question. If each of us have a good final takeaway to give to privacy tech startups on how to prepare for privacy before IPO, what would it be?
Shannon, I'll let you go first.
Okay. So I think it's a great idea to look at a diligence questionnaire that you're going to, similar to one that you're going to receive from an investor, and have good answers to those questions. Like, be prepared to answer those, have a really good story to tell, and have that sort of governance structure in place. And even if it is, look, our IT guy is doing privacy right now because we're 3 people, that's fine. Like that's okay, as long as there's somebody who is primarily responsible and you've thought about it. Like, you've thought about who is going to be for privacy. And that's a really, really important point. And then I would also, the last thing I would say is that if issues were identified in a previous round, I've seen that a couple of times, and it really makes you pause. Like, this was identified before you got, this earlier round, and now you still haven't. It's been, it's been 2 years and it's still not fixed. That definitely, gives us pause. But fixing those things, look at a diligence answer to those questions, and have a good story to tell around privacy and security.
Absolutely. So I think back to the point I think we both made before, make it someone's job. It doesn't have to be a full-time person, but if people don't do work out of the goodness of their hearts, they do it because their boss tells them it's their job and is going to hold them accountable. So make it someone's job to be thinking about security and privacy. Then back to the sort of roadmap point, make sure you know what the issues are. Make sure you know what is important for your company, what the risks are, and focus on those. Then set realistic goals about how to address them, right? There's nothing more common in this practice than the overly ambitious abandoned data mapping exercise that nobody ever finished, right? Like, don't bite off more than you can chew. Spend your time wisely, make sure it's an important issue, and set a realistic goal, but make incremental progress, right? A good privacy governance, security governance is marked by incremental progress over time, right? And if you can show that, even if it's not, the gold standard privacy or security function, but you're showing incremental progress over time, that's going to help you in diligence. It'll help you if things go wrong and you're in litigation or an investigation. It's where you want to be. So it's okay if you're not doing it all at once, as long as it's all addressing what is an actual risk for you, and you're gradually improving. You're probably in pretty good shape.
One important thing to understand is, like, if you don't understand the challenges yourself as a company, how are you going to be able to sell that product authentically to your customers, right? That's a hard thing to do. I mean, you don't want to be hypocritical about your practices and how you use and store and treat your customers' data if that's what you're selling off of, right? You're selling them a solution. So make sure that you do the right thing in-house to be able to sell properly and then actually make money in the long term and pass diligence. So that brings us right almost at time. I was wondering, Adam, Shannon, do you have any other closing thoughts that you want to make sure to convey?
I like that idea, Adam's idea of the making sure that roadmap is in place. I think that goes along with everything that we're saying about privacy. So, you're an early stage company, you can't do everything right now, but have a strategy, have a roadmap, and get some advice on that. To help really appropriately triage your obligations, and that goes to sort of telling a good privacy story.
Yeah, no further thoughts other than just to say thanks to the Rise of Privacy Tech for this great event, and Fatima and Shannon, it's great being with you and everyone attending.
Great. Well, thanks everyone, and enjoy the rest of the conference. It's been a real pleasure.